Okay, welcome to today's class. We are progressing bit by bit. Today we'll be looking at objection and appeal procedure. So the first thing is time limits for objection. See, the time limits for objection, any form of objection, is actually 30 days. You understand? If you are filing an objection, you have within 30 days to file your objection. If you file your objection after 30 days, it cannot be furthered because it didn't meet up the statutory stipulated time period. Now, you can only file for objection where you have been given notice of assessment, best of judgment assessment, additional assessment, or whatsoever. So you have 30 days to file for objection. However, for notice of assessment, when you have given notice of assessment, you have 2 months to pay for your notice of assessment. Now, we'll look at the content of notice of objection. What are the things that must be in the notice of objection? The first thing is it must be in writing and must be addressed to the chairman of the FIRS. It must be raised within 30 days of receipt of the notice of assessment. So you must file it within 30 days. Contain valid ground of objection. You must state the grounds upon which you defaulted to file for your tax return. The notice of objection must contain the following information: the disputed total profit, tax liability, capital allowance, the actual assessable profit, total profit, capital allowance, tax liability that the company believe that they are supposed to pay. So this is what you must state. Reasons for not filing within the stipulated time limit by tax law. So you must state your reasons. So when you state these reasons, it is incumbent on the FIRS to decide whether these reasons are genuine or not. If they are not genuine, they will throw it into the bin. Now, this next stuff we're going to discuss is notice of refusal to amend. Now, when you file your objection, the revenue will look at this objection, and if they found it believing, what they will do is to request for necessary documents supporting your claims in the objection. When they found this evidence satisfactory or sufficient, they will now issue you notice to amend or notice of amendment or notice to pay tax. Now, if peradventure they look at this your grounds of objection and they found it not to be satisfactory, they will issue you notice of refusal to amend. I hope that makes sense to you. Good. Now, you can see I explained notice of tax payable. I also explained notice of refusal to amend. So I've given you the theoretical explanation verbally, so you also read up in the notes which will be given to you. Thank you. Then we'll progress. Tax appeal tribunal. The tax appeal tribunal is a tribunal that is set up by section 59 subsection 1 of CETA. The essence of this tribunal is to adjudicate tax matters between taxpayers and FIRS. And tax appeal tribunal has jurisdiction and power to adjudicate matters relating to company income tax, value added tax, personal income tax, capital gain tax, and any other tax matters that can from time to time be referred to the tax appeal tribunals. The tax appeal tribunal has zones, and there are 8 zones in Nigeria, 6 zones in the 6 geopolitical zones, and 2 zones in Lagos and Abuja. So making 8 zonal offices where tax matters can be adjudged by the tax appeal commissioners. The persons whom are appointed as tax appeal tribunal members are referred to as tax appeal commissioners. They can only be appointed by the Minister of Finance or Finance Minister. And these persons must be persons who have or who are knowledgeable in tax legislations and matters. And they are to hold office for a period of 3 years, renewable once. Or they are to hold office till they are 70, whichever comes first. The tax appeal tribunal shall consist of 5 members, whom shall be presided by a chairman, and this chairman shall be a legal practitioner who has practiced or who has post-qualification experience of 15 years and also have cognate experience in tax legislations and matters. In the absence of the chairman, the tax appeal commissioners shall elect a person who shall preside over their sittings. The quorum that must be formed before a sitting can take place is 3 by law. So with due understanding and explanations, we'll now look at the powers of tax appeal tribunals. Tax appeal tribunal has the power to summon anybody to appear before it. They also have the power to question or demand for evidencing documents. They are also to cross-check the document presented by the witness and other powers that they have as tribunals. Tax appeal tribunal has the power to confirm, amend, reverse, or annul the previous assessments given by the FIRS. And upon doing this, the taxpayer shall now present whatsoever that the tax appeal commissioners has decided to the FIRS and has the power to also pay same amount into the designated account and also file its tax return with the designated micro tax office blah blah blah. Where the appellant is grieved of the judgment passed by the tax appeal commissioners, he has the right to move forward and file an appeal at a federal high court. And there are conditions that you must meet up before you can file an appeal in a federal high court. The first condition is that the appeal amount must not be less than 400 naira. The tax appeal tribunal must be informed duly. The essence of this information is to enable the tax appeal tribunal to transfer your case file to the federal high court for proper hearing. The appeal must be filed within 30 days of the passing of the judgment by the tribunal. As I told you ab initio at the beginning of the class, that you have a maximum period of 30 days to file your appeal. Then if the judgment passed by the by the federal high court is not appealing to the appellant, he has the right to appeal further to Court of Appeal and also Supreme Court. So that is that for today's class. It's actually a short class because it's theory, and I hope this makes sense to you. So see you in our next class where we are going to be talking about VAT. Thank you.